words on our website, as is the first forum that we did. Our goal is to present reliable information that will assist you in making educated decisions for your business in light of new and developing state legislation of the marijuana industry. Please note that the Chamber recognizes that there are many issues that need to be addressed due to the always get that word gets me every time. I think I stumbled on that one last night, on the legalization of recreational marijuana, particularly the impact of this legislation in regard to health and the social fabric of our community. But the Chamber's focus will stay on the issues most directly related to business. As you know, those of you that were with us first round, the forum we did in July, we did an overview of the industry, looked at basic terminology and at the current legislation. And today we'll be focusing on employment law and HR issues. And then in October, it's our expectation that we will discuss some of the potential business opportunities, hear from businesses that are currently involved in the industry, and other topics as our understanding unfolds. And we are open to your suggestions on that. In addition, we really hope to gather input from the business community that will help guide future legislation. We think this is really important as part of the Chamber. It is our job to collect the voice of business and allow your voice to be heard on these types of matters that legislation that will affect your business. So please, at any time, feel free to reach out to us and help us to collect your voice. Let us know what's going on the ground for you. What is it like? What are the things that you're facing? You will be welcome to submit questions in the chat box today, but due to limited time, we may not get to yours, but we will utilize the questions to direct content for future discussion. We'll also be sending out a survey at the end of the event for you to submit questions and comments that will guide you in this continuing conversation. And in respect of your time, we will officially end today at 1 o'clock. We want to say a big thank you to all of our sponsors of the Top of Virginia Regional Chamber's events and programs. You see them listed here on your screen. And especially today, we want to welcome Scott Moore, who is the president of Blue Ridge Bank. And Blue Ridge Bank is our gold level sponsor of this event today. They are also accompanied as a bronze level sponsored by your CBD store. Because of the generosity of these organizations, we were able to provide this forum for you at no fee, and we really appreciate. So here to welcome you and say a few words is Scott Moore.
Thank you, Cynthia. We appreciate the opportunity to be the presenting sponsor for the Marijuana Forum and welcome everybody back to part 2. So we hope it's informative and we keep it at a very high level and hope everybody gets something out of it. It's an ever-changing environment right now in the state of Virginia as well as federally. So we look forward to more changes to come and hopefully we can shed some light on this as we all move forward. So thank you.
Thank you, Scott. Again, thanks for your support of the work that we're doing.
Absolutely.
All right, well, we're ready to get moving into the program. Today's facilitator will again be Ashley Shickle. Ashley represents the Northern Shenandoah Valley Regional Commission and has been an active part of our Chamber Public Policy Committee over the last year. The Northern Shenandoah Valley Regional Commission has been working with stakeholders around our region in regard to this industry for about 3 years now. They were helpful in providing a grant for James Madison University to do specific work studying this industry, as you heard at our first session. And so now to help facilitate the event today and to introduce our speakers, Ashley Shickle.
Hi, everyone. I'm so glad to be here again. Thanks for having me back, Cynthia. So we have 2 participants on our panel today. The first is Andrew Henson of Troutman and Pepper. We got connected with Andrew from our first panelist, if you remember the first session, Augustine. recommended Andrew to us, and Andrew Henson practices employment law with a focus on breach of contract actions, wage and hour litigation, non-compete agreements, executive severance, sexual harassment, and wrongful termination. And as a part of Troutman and Pepper's comprehensive labor and employment advice, they've been monitoring this industry closely, as well as all the changes in employment law that come along with it. So we're very grateful to have Andrew here today. And our second panelist is Dorothy Welch. Dorothy Welch is the Chief Experience Officer at Blue Ridge Bank. And you'll note that Blue Ridge, we just heard from the president of Blue Ridge Bank, their primary sponsor today. So Dorothy is here to represent Blue Ridge as they've been working closely with this industry. They've provided early banking services to hemp and cannabis companies early on. And they also have employees in 31 states. So they're very interested to see what employment law they should be concerned with and following. So I'm going to turn it over to Andrew Henson. And before I do, I want to remind you that we'll be taking your comments and questions through the chat. And after our presentation, we'll get to answer a few of those questions. Andrew.
Thank you. Thank you, Ashley. And let me just queue up my presentation here. Can you confirm that you're seeing what I hope you're seeing? Very good. All right. Well, thanks, Ashley, and thank you so much, Cynthia, for inviting me. I'm Andrew Henson. I'm a labor and employment attorney with Troutman Pepper, and we act as strategic advisors for employers who are trying to navigate, in this instance, changes in the law and compliance strategies to apply to those changes. So I'm very pleased to join Dorothy on this panel today as we unpack the significant changes in Virginia law. One of a variety of changes in employment law. These specific changes relating to the cannabis industry. So just to getting my controls working here. All right. So the recent changes in Virginia law have, as they relate to cannabis, have affected a variety of aspects of the employment relationship, including pre-hiring questions and background checks for job applicants. This reaches as well into the disability accommodation requirements for employees. We'll get into that in a little bit, as there are wrinkles between what is the law of the land at the federal level versus the state law level, and how employers need to be complying with both. This also affects drug testing policies, and I'm sort of double counting here, but there are compliance challenges particularly within certain industries that have an overlay of federal regulation that may require them to do one thing as it relates to workplace drug policies, and the state law, which may be pulling them in a different direction, and how to understand the way to comply with both. So for a little bit of context, I wanted to briefly touch on cannabis under federal employment law, and specifically looking at what is probably the way in which cannabis impacts federal employment law the most obviously, which is the Federal Americans with Disabilities Act, the ADA. So the ADA requires employers who are covered to provide reasonable accommodations for employees with disabilities under certain circumstances. If they're an eligible individual, and the accommodation that they request is a reasonable one, and it would be effective for their disability, employers may be required to do this. When it comes to marijuana, even if a physician wrote a prescription for the use of marijuana for a medicinal purpose, this would not trigger a reasonable accommodation under federal law because of the way that the ADA is actually tied into the Federal Controlled Substances Act. So there's not going to be a situation where the medicinal use of marijuana will trigger an ADA compliance obligation on the part of the employer. But as we'll soon get into, that has now changed in Virginia at the state level for the sort of parallel state disability laws that exist alongside of federal law, and employers need to comply with both. Recently, there has been some loosening at the federal level as it relates to industrial hemp and CBD oil. A 2018 Farm Bill kind of set in motion the removal of industrial hemp and CBD from the Controlled Substances Act. It is still unclear the sort of parameters of legality within that space, but it has not affected the employment relationship through the ADA as of yet. The real issue for today is how Virginia's state laws have changed what needs to be done with respect to employees' requests. So that leads us to the two big changes, and it's a number of different bills, but effectively two batches of changes that were rolled out last year and earlier this year, where Governor Northam signed into law bills that decriminalize simple possession of marijuana. They closed certain criminal records relating to possession of marijuana from public review, set up a framework for full commercial legalization, and established specific employment protections for the use of cannabis oil for a qualified medicinal purpose. So these are the laws that we're going to be really dialed into today. So to start with the pre-employment job applicant aspects of the employment relationship, recent changes in law are in the process of restricting public records from review as it relates to the possession of marijuana and the possession of marijuana with the intent to distribute up to an ounce of marijuana. And by July 1st of 2025, there will be an automatic expungement of criminal records for these offenses. And as the expungement process completes, there will be a corresponding limitation on what employers can ask an applicant during the process of applying for a job, and actually in every respect of the employment relationship. Employers will not be able to command an employee to produce or disclose records of their having been charged with possession of marijuana and in other related offenses, subject to a couple of key qualifiers and carve-outs. So the real takeaway for employers going forward is how to navigate if you're doing a conditional offer of employment before extending an employment offer, and you're doing a criminal background check, and in many industries you're going to be required to do a criminal background check. If you're, for example, if you're a bank that is FDIC insured, you're going to need to do a criminal background check. You're going to need to be paying close attention to, what are the appropriate questions to ask, and are we able to, in this context, continue to ask for criminal charges and convictions of simple possession in the state of Virginia. And certain employers have opted in the direction of a ban the box policy across the board to control for this very circumstance. And Dorothy, I think your Blue Ridge has been active in the ban the box kind of policy as well, right?
We have, yeah. So we try to stay a little bit ahead and, how we're going to handle legislation that we feel will be coming down the road. So we actually kind of joined that movement a while back, and we no longer ask that on our applications. And, as part of the rollout, of the changes in Virginia, we took a look at all of our new hire documents and applications just to make sure we were compliant, because one of the things that we find in banking in general, and particularly in HR, it's always good to do an inventory of all the outstanding documents and questions and processes that you have to make sure that they're all in agreement. And, you don't have a document that you've been using for several years that you forget about that, has a compliance issue.
Right. Yeah, and I imagine particularly for multi-state employers where rather than monitoring the state legislature's activity for each change in the policy specific to that state or jurisdiction, there's a tendency to across the board kind of gravitate towards the prevailing policies in the most restrictive state. I suspect, particularly for a bank like Blue Ridge, where you have so many employees across a variety of states, that there is that tendency to err on the side of being overly conservative to make sure that there's not, you're not having to monitor every day for has there been a new law that's come along that we need to change our policies for.
Right. We tend to be overly conservative on the most liberal approach, I guess would be the best way to put it. Because, there are so many states that we have employees in, and, certainly not to hash out on this call today, but we've seen a gravitation in Virginia over the last couple of years that this has become a more and more employee friendly state as far as the legislation and the employment law changes. And so, as we look ahead and things that are going to come, we could, I think, plan to see that continue. And so we're definitely trying to keep that in mind as we approach changes to our policies.
Yeah. And Dorothy's absolutely right. There have been, this is just one piece of a large, a very large change in Virginia employment law as it relates to cannabis, as it relates to overtime pay, as it relates to disability accommodations, protected classes across the board.
Mm-hmm.
So that, definitely erring on the side of compliance with the most liberal state for multi-state employers is going to be an administrative efficiency there.
And Andrew, I guess if employers were not ready to completely leap to the, avoidance of the box in general, they could probably reword the question in such a way that, maybe before, how oftentimes we asked, have you ever been convicted of any crimes or crime? Maybe now it could just be, have you been convicted of a crime? And since this would not actually qualify as a crime, they would not be obligated to list it. Would that be correct?
Yeah, well, so I think in this law, the way that they're going to be rolling together expungements, and typically in the space, generally when there's been an expungement, employer policies will not be demanding to know the content of that expungement. That kind of defeats the purpose of the expungement. The expungement is supposed to wipe the record clean, and that's been, even in the bank context where you have, federal law on Section 19 that is requiring certain crimes to be reported. There's even then, where a matter has been expunged, at least the banking laws are reflecting that's no longer something that in every case needs to be part of the screening process.
Right.
But yeah. So in addition to records, there is now a new protection that relates to the use of cannabis oil. And the cannabis oil here has a very technical definition. It is not a broadly speaking use of medicinal marijuana, but within the sort of narrow technical confines of of cannabis oil, employers are not going to be able to take an adverse employment action with respect to an employee if there is a written certification by a healthcare professional that the use of cannabis oil is being used for treatment for a diagnosed medical condition. So this will relate closely to the Virginia Human Rights Act and other state disability protections, where we will now need to be considering cannabis oil is sort of a built-in accommodation. You're actually not even making an accommodation; it's actually complying with the current law. And so that's understanding kind of where cannabis oil is, and does the employee who is subject to who is coming forward and saying, hey, I use cannabis oil, do they have a written certification by a healthcare professional? Is it being used for a diagnosed medical condition? If so, then an employer is going to need to figure out how to permit that, subject to some very limited exceptions. And I'll touch on some of those exceptions now. As I mentioned a moment ago, this is not a carte blanche use of medical marijuana law. There is it's got to be within the sort of limited concentrations of cannabis oil, and it also does not prohibit an employer from prohibiting the possession of cannabis oil at work, and neither does it prohibit the intoxication during working hours. I mean that part should kind of go without saying, but fortunately that's been stated in the law. And they're also, because of the way that there are complications with federal law, really around, I would say the biggest one being the Drug-Free Workplace Act, the protection for the use of CBD oil is limited by what an employer is going to be required to do under federal law, and it's not going to prevent them. It's not going to require them to do anything which result in the employer losing a federal contract or federal funding. And there's also some carve-outs for national security interests as well.
Yeah, and so just to piggyback on that just a little bit, I think employees will have, their own interpretation of rules that have come out, and it's certainly the onus is on the managers and HR team to understand, what that really means, what we're really obligated to and not obligated to do. And so, I think now that we could hear, hey, pot is legal, or CBD, and you can't test me for it anymore. And that's not exactly true. That's not exactly correct. And certainly, just because it's not a crime doesn't mean that, there can't be issues regarding industries. And as Andrew said, the requirements for federal contracts and, the different legislation that companies face and regulation, especially as it comes down to public safety and things like that. So, if there's reasonable suspicion, or if it's part of an investigation from an accident or a safety hazard, I think there's definitely some times that, additional testing or information may be required. And it's probably a good idea as we head down this road to even have supervisors and safety people in particular industries, and maybe manufacturing being one of those, trained a little bit more on the signs of impairment and, accurate documentation and thorough documentation, because, as it relates to all things HR and personnel related, the documentation and the observations will be key in a lot of this.
Dorothy raises an excellent point. Just because it may no longer be a crime to possess marijuana, that in no way means that employers cannot prohibit marijuana in the workplace. So that I think there is there may be some misunderstandings kind of in the aftermath of these changes in law from employees that may think, to Dorothy's point, that it's sort of an across the board thing that they can do now, which is not necessarily the case. I mean, if it is within the confines of cannabis oil, if it's under a medical certificate, from a healthcare provider for a diagnosed medical condition, this is something that employers will need to be amenable to allowing. So and this segues into drug testing. This is probably to be the area where it comes up the most obviously, outside of an employee just disclosing that they're using cannabis oil. It is, if there's a positive screen and a drug test, employers should be mindful of whether or not they should, if there's been a positive screen for someone with THC in their system, putting in place a policy which asks the employee of the circumstances of their use would be well advised. And if they come forward and show the certificate, and they show that they've only been using it for that purpose, or they kind of represent to that effect, that's something that an employer would need to weigh carefully in terms of allowing that to continue, so that you do not violate this new law here.
I suspect, some employees will be quick to go through the registration process and others will not. And maybe that won't be as known or as widespread, but eventually more employees will catch on to the fact that, there is a process, and, the registration process and certification process, and then that will provide certain carve outs and protections.
Mm-hmm. Yeah, and so to segue then into the next related law of how disability accommodations work in this space. As we mentioned earlier, under the ADA, we're not going to have this compliance obligation, but in Virginia, we'll need to be paying close attention to this. If it still remains, the onus is still on the employee to come forward and say, hey, I have a disability, I need an accommodation. And so when it comes up in drug testing or wherever it is, they're going to need to put the employer on notice, or at least to a place where the employer needs to know, the employer should know that they should be asking further questions, a duty to inquire that as to whether or not an accommodation is being requested. If you're just screening for positive drug findings and making quick termination decisions, without having any knowledge about a person with a disability, that's the employee has got to come forward in order for the sort of duty to be triggered back on the employer to make some sort of accommodation. The real question I think here is and this is something that the courts will have to determine, is the cannabis oil protection does not apply to the in the workplace during working hours use. But that doesn't necessarily mean that it would be it is precluded from being a reasonable accommodation. A court could still find that, yes, the cannabis oil statute does not extend as far as in the workplace use of CBD oil for a diagnosed medical condition, but perhaps the Virginia Human Rights Act does. So when we're in this space of uncertainty and we're waiting for interpretation of the law, we should be speaking with your counsel about should we proceed with this adverse employment action, given that uncertainty. And I think that we'd be better advised to be more cautious as it relates to taking adverse employment actions off something that could potentially be subject to disability protections.
I think there's a lot of gray area here as it relates to testing in general and whether, something's just present in someone's system or if they've actually come to work impaired. So to Andrew's point, in cases or situations like this where we don't have a whole lot of finite data or clear guardrails on what we should and shouldn't do, it becomes, more important that we probably err on the side of caution.
Right. And that's right. And one of the other challenges here is just the current science on being able to detect intoxication of THC is not commercially available to my knowledge. And so in the absence of that, if someone has an accommodation and they're just kind of acting off, and particularly in an area where you have, where there's a lot at stake, for example, like a manufacturing environment, if someone's on the manufacturing floor and they're kind of, wobbling to and fro, and they have this, the certification, that I think that would counsel the caution in the opposite direction, of trying to make sure that safety is not being compromised, even if someone is using this, subject to a valid accommodation. So there is definitely some uncertainty about being able to accurately detect, who is, even where they have an accommodation given, who is using CBD oil appropriately outside of the workplace, versus someone who is, maybe using CBD oil in the workplace or supplementing it with other forms of marijuana, even for a medicinal purpose, that may be, compromising the sort of safety of the work environment. So there's a very delicate balance here that I think is going to be it's going to be a challenge for a variety of employers to understand, how to thread the needle of protecting these rights while also protecting the safety and security of the workplace. And on that note, I will just kind of touch on a couple of salient compliance challenges of state and federal law. Probably the biggest one is the Drug-Free Workplace Act of 1988. And this law applies to, in part to organizations that are receiving federal grants or contracts. And if so, they're required to have a drug-free workplace policy that prohibits the use and possession and manufacture of controlled substances in the workplace. And it will require some discipline for those who are convicted of drug offenses occurring in the workplace. I think one of the, Virginia is not the first state to enact a law like the one protecting the use of cannabis oil, for example. And in other states that have previously enacted very similar laws, there has been litigation where an employer has, there's one up in New England where there was a new hire who said, I used CBD oil for a health condition, and the employer said, well, we're a federal contractor under the Drug-Free Workplace Act. We if something comes up in a drug testing, we're going to have to to withdraw our offer because of that. And sure enough, because the employee said that they were taking it, sure enough that there was a finding in the drug testing, and they withdrew the offer. And there was subsequent litigation, and the courts narrowly construed the way that federal and state law work here, and noted that the Drug-Free Workplace Act does not require drug testing in the workplace, and therefore the way in which the employer, even well-intending, was administering its compliance with the Drug-Free Workplace Act, it was going over and beyond what was actually required by the law, and in so doing was actually violating the state law. So the there is it can be a tightrope in certain areas, and I think this is probably going to be one of them for employers who take an overbroad understanding of the meaning of the Drug-Free Workplace Act. They'll need to be talking with their HR and employment counsel to figure out where do the compliance obligations under the Drug-Free Workplace end, and where do the compliance obligations under the new Virginia laws begin? Because they're pretty close to each other. So that's going to be a big topic for particularly in Virginia, particularly in Northern Virginia, where you have so many federal contractors. And the other big one is how certain financial institutions are going to, which are required to scrutinize and have a background check on applicants for FDIC insured institutions under Section 19. How do they comply with their obligations to screen for certain drug offenses, and specifically those with sort of intent to distribute, and how do they comply with those obligations and also comply with state law? And this is something that I think the jury is still out on how this is going to work together. There have been changes recently in the federal banking regulations around Section 19 that have made it more permissible for those that may have a criminal record to nonetheless be employed by a bank, an FDIC insured bank. But it's still a process where if you can't thread the needle of one of these exceptions, you actually have to go and file an application to allow the bank to employ this individual with that background. And most banks don't want to go through that process. It's cumbersome, and it's uncertain. And so they typically will just draw the line at if we need to file an application to hire this person, we don't think we can move forward with that hire. Dorothy, is that similar with your experience?
Yes, I mean, it would have to be a very extenuating circumstance before we would go through a process like that to file the application to hire somebody. I do think it's a little bit broad in the definition, as far as, certain drug offenses and things like that. But generally speaking, banks just err on the side of caution with that. And because we have a fiduciary responsibility in many cases, with dealing with the public.
Mm-hmm. Yeah, that's right.
One thought, just to kind of follow the drug-free workplace slide. One thing to consider with that is insurance policies, and just making sure that your company policy, your HR policy, your handbook, however that's being updated, is also in agreement with your insurance policy, your corporate insurance policy, and any bond associated with that. Because I think in Virginia there was oftentimes or has been drug-free workplace discounts, and so making sure your policy is worded appropriately to reflect what the actual policy is and if it's been updated.
Yeah, that's right. Exactly right. And that kind of brings me to the Q&A. If there are questions, I'm looking in the chat here and I see a few, and I think this one's from LaPearl. There was a question about federal contractors operating in Virginia, so there's a question about security clearance as well, which I'll need to punt on the security clearance question, because that is a very large compliance issue in its own right, and I think we have some government contracting counsel that can counsel on that. But as it relates to federal contracting work that is not necessitating a security clearance, or that just generally obligates them to comply with the Drug-Free Workplace Act, that's where you're in that balance of, understanding and not exceeding the parameters of what is required under the Drug-Free Workplace Act, or at least not exceeding them in a direction which would then create a violation of state law, and understanding where exactly those places are. And it's really going to be dialed into the issue of cannabis oil, and if someone is otherwise complying with Virginia law, you're probably going to need to err in the side of allowing it, unless it's something is that they're asking for use in the workplace, or they're or they just have the appearance of being intoxicated, and the stakes are sufficiently high, in terms of your sense of the likelihood that they are intoxicated, that you would want to get them out of that workplace. But that's just, you're on a knife's edge in some areas, with respect to where federal obligations and state obligations begin.
Andrew, I want to look at this from a more specific example. So Cynthia asked, if an employee ingests a CBD gummy and is for a diagnosed medical condition, can you limit their job duty, like driving a forklift or using heavy equipment?
So, I mean, we have to, I guess we're assuming that the CBD gummy it did not exceed the concentration that was allowed under state law, and then it came with a medical certification for a diagnosed health condition. In those circumstances, I mean, the doctor you would probably need to require the doctor to opine. In fact, not probably, you definitely would need to require the doctor to opine about the restrictions and limitations on this employee's ability to work. And if they say, this is for the treatment of fibromyalgia, and notwithstanding the fact that it's a CBD product, there's going to be no impact on their motor function or cognitive functions, then there's probably not going to be any impact. And you can potentially get a second opinion, but I think that would, you would also be kind of in an area where there are a lot of confidentiality restrictions on employers. You can't just pick up the phone and start to grill the employee about, well, tell me about this disability, and how long have you had it? I mean, we've been talking to your doctor. You can't ask those questions, certainly under the ADA. And so if this is going to be kind of a question and answer session with that healthcare provider to understand affirmatively what the restrictions and limitations are. If there's a question as to the ability to perform motor functions in a way that would be required within the job, then I would certainly advise to take that employee off the forklift without question.
Okay, so Nina submitted a question. Nina, did Andrew's answer respond to your question in the chat? It was more about in the cases where CBD oil does not contain THC or it's derived from hemp, does the employee still need a written certification from a medical doctor?
So I'll tell you, if it's commercially available, if it's not, I don't know what is over the counter and what is not over the counter in terms of being able to get access to these to CBD, with or without THC. So I can't speak to that, but I would be speaking to from an employer's perspective is really just the narrow question of whatever they come forward with, whatever they're using, does it fall within the definition of the protection in the state law? And if so, then the employer's response is obvious. We have to permit that, and permit the use of that, provided it's not within the carve-outs of use during the possession, on premises, use during working hours. If it doesn't fall into one of those exceptions, then I would say that an employer has to allow it.
So this question is kind of coming from the employee's perspective. Well, both. Nina says these products are readily available, and people, I'm assuming people means employees, are scared for the security of their job, even though they're not getting high off of the product.
Yeah. That's right. I mean, and I mean, there are probably circumstances where, it might kind of fall through the cracks in terms of, an employer is trying to carry out their duties to comply with the law, to have a safe working environment, to promote the sort of safety and well-being of their employees, and they may not be able to tell in every case if someone is getting high or not, and so they're really kind of having to just follow the law, follow the healthcare provider's advice, and I can certainly appreciate that there may be circumstances where that really does help that individual, but maybe it doesn't fall within the square confines of the law, and an employer is permitted to take adverse action against that. There may be, but I think right now it's kind of up in the air what my gut tells me that employers are probably going to be leaning more in the direction of allowance than not. So unless they have significant federal laws that they are seriously concerned about complying with, one of them being the Drug-Free Workplace Act. So my sense is that employers will be leaning in the direction of permitting, but I know that that's not going to be the case in every workplace. So I appreciate the challenges there for that employee.
I think it's important to remember too that it's important that all employees are kind of treated the same when you're looking into something like this, and that we can't turn a blind eye to drug use or CBD, or we can't treat individuals differently or turn a blind eye in some instances and not others. So there has to be some consistency across the board in how employees are being treated, and what's being taken seriously, what is being elevated, and just keeping that in mind, along with all aspects of employee relations. Right.
Yeah, Dorothy raises a really good point. I mean, particularly for the disability accommodations analysis, one of the first questions that I will typically ask an employer when they come to me and say, hey, an employee is requesting this accommodation, should I allow it? The first question is, well, have you allowed it for other people without a disability? And if the answer is then yes, then you're like, you gotta, let's talk about what that really good reason is that this person should not get what everyone else got. And maybe it's apples to oranges. Maybe the person's position is different. The level of responsibility is different, to where that would be warranted that you can't provide that. But the sort of baseline availability, working conditions to employees, that's something that you're certainly going to need to, in most cases, apply to that employee who's coming forward and requesting an accommodation. That's a critical point.
Okay. So La Pearl's let's keep talking about reasonable accommodation for a second. If an applicant has a medical authorization for marijuana and applies for a job where the company restricts drug usage, can that person still be considered if they meet all of the other qualifications?
Medical authorization. I mean, I guess that would be, it's sort of asking the employer to pick and choose which policies they're going to apply. And I think I don't think that's probably not going to be something that employers can really allow, particularly for a driver. I mean, at CDL, I'm not sure if that's a FCS, MA, DOT subject position. But I know in particular for drivers that are regulated by the DOT, I mean, that's going to be a big area for carve outs. And they're going to be leaning in a much more conservative direction in terms of, who they're allowing to, operate a motor vehicle for, interstate carrier purposes. But I mean,
yeah, I would say CDL, that's going to be DOT regulated. So I think you're right. And that's also going to tie directly to insurance policies and rates for employees.
Yeah, that's another good point is, what sort of, I'm not sure if Dorothy, you see these things come up in workers' comp insurance policies and other kind of general liability insurance policies, but making, figuring out what your policy requirements are for your carrier is going to be also a central question. Dorothy, have you seen these issues come up in some policies, either industry wide or have you heard about this in the banking industry in particular?
No, not specifically as it relates to this. I'm probably applying my experience with DUIs really to this situation and how insurance underwriters will periodically run the driving report of our insured drivers for company vehicles and people doing business or driving in the course of business for our company. And, they will certainly flag DUIs that have popped up in the meantime. And, that's certainly something that has to be considered then, with the pricing, the premium, or with the continuation of those employees in that role with the company.
Yeah, right.
Because it's seen as a risk. So I can imagine that this would fall into the same risk underwriting kind of formula.
Sure. Yeah, I mean, whatever that policy states is going to be, it's going to need to, the employer is going to need to look to see what the statute says first before, figuring out if they need to do something, if their insurance policy is asking them to do something different, and if that's the case, follow the statute. But,
right.
But absolutely.
You're just going to mitigate either on the front end or the back end. There's a mitigant, and it's just where it's going to fall.
Yeah.
So Andrew and Dorothy, we're coming up on the 1 o'clock hour here, and I have two final questions. The first is, this is a lot of information. This is a super challenging topic. Everything that we're hearing is new. It's for the first time, almost every time. And so Andrew, if you could summarize, or maybe Dorothy, summarize some steps or focus points for the businesses that are on the call today. What should they be doing when they leave our call? And then where can they go for more information, or what media outlet or who should they be talking to follow changes on this topic as they come up? So a quick summary, what should people be doing when they leave our call? And then where or who can they contact for more information as things change?
I'll maybe give a high level overview first, Andrew, and for more of a novice perspective here, I think the things to focus on first are what you absolutely cannot or should not or not allowed to do anymore. So, the questions, the background checks and things related to that, I would certainly focus there, and just an audit of what your policy and practices are to make sure that they're compliant. There are a lot of gray areas here and things that we need to figure out, and that, that not only relates to the employer, that always relates to the area that's governing the employer, right? Because they're trying to figure it out too, because it's new legislation. So I like to hope that there's a little bit of grace, in regards to that, as we're trying to figure it out. But the absolutes, the things that, we can no longer do as employers, that's where I would certainly focus first. And just making sure that, all of your policies and practices are kind of synchronized, and probably some high level supervisor, overviews and information rollout, so that they at least have a basic understanding of the changes, and, can keep up with the conversation and what to look for and what not to look for, and things like that, or what not to do. As far as information, I personally haven't seen a whole lot of detailed information roll out from SHRM at this point. I maybe missed it, but I'm sure more will be probably forthcoming from the group. So at this point, I know the regs, or not the regs, I'm so used to talking banking. The code is probably the best resource, but I'll kick that over to you, Andrew.
Well, I'm a great resource, so you're welcome to call me. I'll put a shameless plug in there. But really though, if there are any employers on the line that do have questions, please let me know. We have been troubleshooting compliance strategies for many employers in this region and in others in Virginia that have these sorts of questions. We also have Troutman and Pepper's hiring to firing blog, which regularly posts out updates in not just in the Virginia area, but nationwide as it pertains to the employment relationship. And so, in terms of resources, I would kind of suggest folks in that direction. I'm sure there's something out there on SHRM. I haven't seen it either, Dorothy, to your point. But then I think probably the two biggest questions that employers should be asking themselves right now is, am I asking questions on a background check that I shouldn't be? And an employee has come forward asking for some sort of accommodation from my, pre-existing policies. What do I do? Those are probably the two, to sum it up as generally as you can. Those are the two big questions that employers need to be asking. The first question about background checks is going to be going to be relatively easy to answer. In the accommodation context, the disability accommodations is one of the messiest areas of employment law, and it is not subject to bright line rules. So that's above many other areas of employment law. I think that's the area where, if you have questions, chat with an attorney briefly about what a reasonable accommodation looks like, and if that's something that might fall within that bucket. So those are my comments on that front, Ashley.
I can vouch for the blog from Troutman. It's a great resource.
Shameless, it's wonderful. So Dorothy and Andrew, we really appreciate you being here today. I'm going to turn it back over to Cynthia to close us out.
Right. Well, I just want to again extend our thanks to Andrew, Dorothy, and all the folks at Blue Ridge Bank for supporting this opportunity to have this conversation. There is a lot to be handled in the days to come, so stay tuned. Thank you again, Andrew and Dorothy, for your time, and Ashley, great job. We look forward to seeing you again in October at the next and final forum. For now, have a great day doing business in the top of Virginia.